Our next file is People of the State of Michigan versus Richard Franklin. This is going to be case number 25-14089-FH. Please.
Manager.
Robert Hertzelt and Mr. Franklin, who joins me to my left, Ron.
Thank you. You may be seated. Also here this morning is Mr. Kevin Steffel, CH Michigan Department of Corrections. Appearing today on behalf of Mr. Potter. Potter is the officer who prepared the CFJ, the PSI for the file. See if I had any corrections. All right, I don't see you on Miss Carey. All right, and Mr.
Yes, just a few relatively small ones, Your Honor. On CFJ 284B, pages 4 and 5, on 2 of 25, it mentions being on bond. I talked to my client. I believe that was occurring at the same time as 1 of 25. The dates are very similar. He advised me he does not recall being on bond when that occurred. So the court is
that makes sense. We'll go ahead and change that on bond status there, Mr. Thank you. Your next one, sir.
Yes, Your Honor. CFJ 284V, page 13, offense 22 of 25. When it says habitual offender 45th, I'm sure it meant habitual offender 4.
Oh, yeah.
Just so we got that accurate.
Yeah, I don't think there's that. All right. Got that, Mr. Stepleton? CFJ 284B, page 13, under entry 22 to 25. The fifth line down. Thank you. Anything else, Mr. Hartfell, regarding corrections?
No, Your Honor.
Allocution.
Yes, Your Honor. I have reviewed the PSI and the recommendations with my client. He was willing to work with our office social worker, Mr. Henry, who I believe submitted a mitigation report to the court as well.
I had that. Right.
Yes, I do always thank Mr. Henniger for that. He always does quality work. My client also has more support in the courtroom. His longtime partner and his daughter are here. They've been very supportive of him throughout the proceedings, and I do thank them for doing so. With this type of underlying situation, I would like to add some context for the court. I'm not trying to make any excuses, just some explanations. My client was heading to work. He misunderstood some of the laws. I'll put it that way. My client has clarified with me that he definitely did not consider himself a sovereign citizen or maybe the extremes that the court sometimes sees. But there's so much information out there, misinformation, just on the street, stuff that quote unquote everybody knows. You have the right to get someone's supervisor, that you can travel certain ways that you can't, things of that nature. And unfortunately, that pollution, I'll call it, a bit of a brain rot society, it's kind of hard to weed out. And sometimes, unfortunately, we end up in situations like this. But my client has advised me that he definitely understands the rules now. It was a harsh lesson, but it was one that he definitely will not forget. He's cognizant of the fact that he has had issues on supervision. However, he pointed out to me, and I do believe it accurately puts on the PSI, that the last time he was actually supervised, he completed that successfully. He wanted me to communicate that to the court. He does take pride in that. He's advised me that his youthful indiscretions probably lasted longer in adulthood than they should have, but he did learn that he needs to obey the rules. And again, he had every intent to obey the rules. He had to learn these rules the hard way. But it's a lesson that I don't doubt he will never need to be taught again. I don't doubt if the court did adopt the recommendation and give him supervision, he would complete successfully. He did have a relatively minor issue on bond in district, but that was resolved. He hasn't had any issues while up the circuit. I really believe he's highly motivated to do well. And just for some compare and contrast, I know this isn't as extreme as some of the other ones the court has recently seen. I'll phrase it that way. Yeah. And I ask the court to factor that in. Thank you.
Thank you. Please, Carrie.
Keep mine short and just ask the court to follow the recommendation.
All right. Mr. Franklin, you have the right to make a statement if you choose to do so. Is there anything you wish to say today, sir?
No, Your Honor.
Okay. All right. Well, this is not like our last R&O, except for the refusal to comply with orders. I understand the defendant now knows that what he was doing was wrong. And if he chose to believe what other people out there on the internet said, well, that's on him. And I suspect he chose to believe it because he was violating the law. It says right here, why'd you do it? Only way for me to get to work at the time. No, that's not a good answer. And also here, while the blood alcohol level was low and showed a 0.02, lab tests also showed the presence of marijuana. Means you shouldn't have been driving a car because you didn't have a license and you knew it. And you shouldn't have been driving a car because you had marijuana in your system. It's done. So you started being a jerk to the officers because you knowingly were violating the law. And when the officers tell you to get out of the vehicle, get out of the vehicle. Real simple. You don't own the highway. You don't own any of the roadways unless it's on your own private property. So you're agreeing you're going to drive on a roadway. You're going to follow the laws. The officer tells you to get out of the car. You get out of the car. And if you were silly enough to buy into or even believe any of the garbage on the internet, you did that at your own failed choice. But never mind that. You should not have been driving a vehicle because you do not have the lawful right. Get somebody else to drive you. What you're telling your family is, kids, it's okay to break the law when you choose to do it. No. I'm sorry, but I appreciate Mr. Ardell. He made a good argument for you. Bringing your family here is great, but here's what I tell you. Do not use this person as an example. He's trying to tell you that it's okay, that as long as you've got a good reason, you go out and break that law. But I know you can't drive a car and you don't legally have the right to do so. Go ahead and do it. No. So part of a sentence is not only punishment and deterrent, but it's also general deterrence to the outside. I don't know if you know everything about your father's history. It began 30 years ago with lots of crimes as a juvenile, with lots of violations of probation in juvenile. Multiple cases all going on at the same time back in 1994, 93, 95, 97. And this still smoking marijuana, that hasn't helped you. Alcohol hasn't helped you. You were going to work with marijuana and alcohol in your system. You know, marijuana's been getting you in trouble for a long time. Driving license suspended. Heck, you got your first one back in 2000, 25 years ago. Probation was revoked in that file. You had multiple cases on bond, multiple cases where you've had probation violations, multiple cases where you've been convicted while they're picked up while on probation. In fact, most of your criminal offenses have occurred while on probation, while on parole, or while on bond, at least up until 2017. By the way, Mr. Stephan, I think I'm entry 22 of 25, that one occurred to be on bond. Anyways, you've got short gaps in time, even back in 2024. It was just some kind of impeding traffic, but you made it a month. They're just a couple months before you got this case here. So I don't know what it takes. And I appreciate what the social worker does for the public defender's office here. And then it says here that he has turned his life around. Well, there seems to be a time when you did it, when you stopped violating probation and parole, but you still have a longer criminal history than most people. And even most of the defendants who come into court. So, stop breaking the law. Maybe stop drinking. Maybe stop using marijuana, because so far it hasn't helped you out. And when the law tells you to do something, it is clear to me. You may have misunderstood what somebody on the internet spoke about. Maybe it was somebody who believed in the sovereign citizen stuff, which is just not true. But you have violated the law, you don't care. At least that's what I see. I don't know what to do other than send a message. Hopefully gets in, because so far over the last 40 years, it hasn't gotten any 30 years.
Your Honor, I should have mentioned it earlier. I apologize. If the court did do any jail, he works Monday through Thursday. He's available. The court want to do it on weekends, Friday, Saturday, and Sunday. I apologize for not mentioning
Okay.
that.
Where does he work?
He works at the Lake City Forge, Your Honor.
And how is he going to get there?
I don't doubt he'll find a legal ride, Your Honor. He's mentioned family members can help him, Your Honor.
What days does he work?
Monday through Thursdays is days of the week he works on.
Court places the defendant on a period of probation for in 18 months. The court adopts terms and conditions that are listed in CFJ 145, pages 2 and 3. I find that those terms and conditions are well suited for rehabilitative purposes based upon the person's prior history. In this case, court sentences the defendant to two $50 state minimum fees, a $75 fine victims' right fund fee, a $200 court cost, a $500 fine, a $200 attorney fee. Supervision fees are $30 a month or $60 a month if there's any electronic monitoring. The court for both offenses sentences the defendant to $180 days with 50 days of credit. The court will allow the defendant to do community corrections work release program. He is to report to the jail beginning this Thursday. At what time does he get off of work? He's to report to the Wexford County Jail by 5 p.m. on Friday. He'll serve throughout the weekend, and they'll probably let him out on Mondays. But yeah,
Did you mean Thursday?
did I say Friday?
Yes.
Thursday. Thank you. I'm sorry I said Friday.
It's okay.
Yeah, I got you. No, thanks for catching it. And you will be released on community corrections tethered, and you will follow their instructions. What I've started doing is I no longer say what those instructions are, other than they will be set through community corrections, which will require that you must provide proof of employment. So over the next couple of days, you better get a letter from your employer. Right? And so today you're going to leave here. You're going to go down to community corrections. They're going to put you on a tether so you can work until Thursday. And they'll ask for you to provide proof. Hopefully they'll let you go to work today and have you give the proof tomorrow or something, or somehow over the day. But you got to prove it. Lots of people go down there. And this is an issue that's going to bite the public defenders. I'm no longer going to accept the public defender telling me they've got a job. Right, that's not to pick on you, Mr. Hartel, or any of the council. It just invariably proves that most of the time the defendant's lying, never has the job. I'm going to believe you got the job here today. I'm just going to ask you to provide proof of it. All right. Anything else today, Mr. Step?
No, no.
Anything else today, Miss Karen?
Okay.
And yes, ma'am.
Do you want to set a release time for Monday morning? So
Oh.
he makes it.
What time do you go to work on Monday?
I'll be there at 5 a.m.
Oh, 4. I don't need to go over the terms and conditions of appeal since this is a misdemeanor file. All right, thank you very much. Don't violate your conditions of community corrections.
It's sir.
Thank you.